Good evening, everyone. This is Omar Serrato with the Tilted Lawyer podcast. I had received from my best YouTube friend, Lauren Knighty, the transcript from the March 6th hearing where they were discussing the scope of protections. And then the judge was wondering out loud, like, why do we need to expand these protections? Why isn't my original orders good enough? I mean, if anybody violates them, they're going to be held in contempt of court. There was a lot of stuff going on. Not many of you got an opportunity to see what was discussed, but I've had a chance to read through 55 pages of the transcript, and I'm going to share my thoughts with it. It's coming. I don't know if Lauren Knighty is going to jump in at any point. She kind of just texted me and said she might be a little bit too baked. Matter of fact, she specifically texted me to let me know that she's a vegetable. And so whether or not she ever comes in, we'll see. She has a link. Lauren, it's the same link from last time, just in case you're interested. We'll see what happens. Otherwise, it's just going to be me breaking down this hearing and letting you know my thoughts. We're going to have some fun tonight. Let's get started.
Whatever you might be going through and wherever you might be, this is Omar Serrato with the Tilted Lawyer podcast. I'm here to take your mind off of things. Yes, I'm an attorney. No, I'm not giving you legal advice. We're going to sit and talk like people, as these are the candid thoughts of one practicing attorney, and it's after hours. So have a seat. Feel free to have a drink and join me. Let's get started.
Every time. Folks, before I get started on my rant, can y'all just confirm that you could hear me through my microphone and I'm not like, I don't have it inadvertently muted or anything? Just need confirmation from one person that my voice is heard. I'm going to assume it is because nobody's telling me that it isn't. So no one just confirms. Cool. So let's get started. All right. So this all began December 2024, very brief rundown. In case you've been living under a rock, Blake Lively files a lawsuit in the Southern District of New York accusing Justin Baldoni of various things, creating a toxic work environment, sexual harassment, a PR smear campaign, all kinds of stuff. She claimed that Baldoni, along with his PR team and business partners, coordinated with media outlets to smear her reputation, leaking damaging stories, falsifying stories, in an effort to try to destroy her reputation, in an effort really to silence the complaints against Justin. She thought it was retaliation. And she's claiming it wasn't just gossip. It was an orchestrated attack, planned, premeditated, with real financial and emotional consequences. And so Baldoni says, like the hell with that. He files a countersuit for $400 million, claiming that Blake lied about the harassment to gain sympathy and media attention. She's playing the Me Too card, all of those things. His legal team goes on to argue that Lively has weaponized the Me Too movement, her position or status, or her desired status as an aggrieved female who is a victim of sexual harassment, whatever you want to call it, she has turned a private dispute into a public witch hunt for a guy, Justin Baldoni, who has spent his entire Hollywood career trying to cultivate an image that was positive to women's rights. His defense was that the Lively lawsuit was a fabrication that was designed specifically to ruin his career, and that the negative media coverage was not a smear campaign. It was justified responses to her own actions, because on the set of It Ends With Us, over the course of many months, extending over a year, she was being a bit much. There were demands, there were changes to the script, there were wardrobe changes, there was just all kinds of stuff. She sicked her husband, Ryan Reynolds, on Justin Baldoni in what some have speculated was a jealousy-fueled rage or rant towards Justin for whatever reason. He snapped at her because after having back surgery, needing to be concerned about the kind of weight that he was lifting, he had the nerve to ask Blake Lively how much she weighed, to which Ryan Reynolds demands, "How dare you ask that question to my wife?" There was another occasion where it was supposed to be like an HR style meeting where everybody was there to air out their grievances, but it turned into a shouting match between Reynolds, really directed at Baldoni for whatever reason. Who knows? So we have all of those things going on, and now what I think that this case is really going to be famous for is the PR war, the public relations war, the warring PR firms. At the same time that Lively's lawsuit is filed, her publicist, Stephanie Jones, sues another PR exec, Jennifer Abel, for stealing clients and helping Justin execute a smear campaign. All these things are alleged. Jones claimed that Abel worked for her at Jones Work PR, secretly leaking confidential information, working with Justin, actively trying to sabotage Lively's career. So now we have these two lawsuits in parallel. The one that you guys are all familiar with is Lively versus Baldoni, of course. Hollywood defamation case, sexual harassment case. Great. What we really have also is Jones versus Abel, a PR industry landmark case over stolen clients, business secrets, leaked information, and they both center around one explosive claim, which is specifically that Justin Baldoni and his PR team plotted to destroy Lively behind the scenes. Similarly, Justin has claimed that Blake Lively, in conjunction with her PR team, in conjunction with Ryan Reynolds, was actively trying to steal credits and other aspects of Justin Baldoni's career, specifically trying to ruin his reputation for financial gain. That's where we're at. So the protective order battle. Lively's legal team writes a letter to the judge, basically explaining that they are terrified of leaks and that they have good reason to be, that there have been prospective witnesses on their list of prospective people to be deposed, to be involved with the case, that they've been getting threats. Case is already playing out in the media in a very public way. Highlight Justin Baldoni's legal team authoring a 168-page timeline of their version of events in response to Blake Lively's lawsuit against them. That resulted in Lively amending her complaint, trying to throw additional evidence to support her claims, which largely fell flat because of how the PR of how the public has taken to this lawsuit, dissected every allegation, dissected all of the available evidence out there, and have wholeheartedly decided that it's probably like 98-2 in favor of those who are supporting Justin Baldoni through all of this. Now, that's between the two of them. Like I said, and I've always said, the more interesting legal battle going on right now is going to be behind the competing PR firms, and we'll see what's going to happen with that. So they ask the judge to grant a protective order where they wanted certain evidence to be kept confidential. But it wasn't just like your run-of-the-mill protective order, because the judge specifically has a protective order that is basically boilerplate. It protects everybody. Whenever anybody needs protection, this is the order that we use. It's good enough for everybody else. Why isn't it good for you? Lively's team wanted an attorney's eyes only designation, which means that only the attorneys, not even Justin himself, would be able to see certain documents and evidence. Why? Because they don't think that Justin Baldoni's PR team could be trusted. If he sees certain evidence, he was going to be bound, or his team was going to be bound to leaking it to the press. Attorneys are supposed to be, they have to obviously see the evidence, but they're bound to a higher standard. If the judge puts forth an order that there's not to be any leaks to the media, whatever, which this judge is not inclined to do, by the way, then, you at least have the confidence that the information is being protected by a licensed attorney that has a lot at stake. There's already proof of Baldoni's team bragging about getting information out there without leaving fingerprints, according to Lively's team. Baldoni's lawyer said, what in the hell are we doing? It's a ridiculous request. They say that Lively is probably really been so hamstrung in the media by this case, meaning the public outcry against Blake Lively because of the evidence that's publicly and readily available. And by the way, not just with respect to these PR leaks, but in the media, in the press, in the advertisement for the movies, on film, it's all out there. They're public figures. The public has opinions about it. And what they're really trying to do with these protective orders, according to Baldoni's team, is they're trying to shield against key evidence, because I think that they know that there's not a chance that Lively is going to be rehabilitated by the release of additional evidence. I think it's much more likely that Lively is going to be hurt by whatever it is that's coming next. And they are smartly trying to get ahead of it, saying, look, enough is enough. We're not going to litigate this in the press. Whatever's done is done. Let's just keep this under wraps until March of 2026. That's what they say. Baldoni's team argues that Justin has a right to see the accusations against him and to defend himself properly, meaning whatever evidence that is uncovered, there's not a reason why we shouldn't be able to give it to our client. He has a right to face his accusers. He has a right to know what evidence his accusers have against him. It's a part of due process. It's constitutionally protected, and what the fuck? So they accuse Lively of trying to create a different set of rules for celebrities, saying essentially that fame doesn't mean that you get to hide from justice. That's where we're at. So what is the judge saying about all of this? In a nutshell, before I break it down more fully, he acknowledges that there are some protections 100% are going to be needed. But he says that Lively would have to be very specific about which documents were high risk. And we got to define what is high risk. And that eventually a lot of this evidence is going to become public anyway. So what are we doing? And why are greater protections needed? If anybody steps out of bounds with the current orders, the way that they are currently crafted, they're going to be held in contempt of court. What's with the extra, whatever? There's some things that are definitely going to be secret for now. But once this case goes to trial, there's not going to be anything that's going to be let out. And I think that's kind of what the judge is on about there. So what to watch for in the next few months? Number one, if judge grants the attorney eyes only order, Justin's team is going to be limited in how they're going to be able to fight back. They're no longer going to be able to use PR as a tool or a mechanism to put Justin's story out there. Secondly, I just don't know how realistic. I've never litigated a case where it's like, hey, you can't show evidence to your client. It's just overwhelmingly strange. And so I'm not even sure how that would work just in practice. If the judge denies the order, then Lively's team is going to have no protections from any, you could call them leaks if you want to, but whatever is going to get out is going to get out. There's not going to be any more protection from the media as it stands. There's text messages that are being discovered. That's part of what is desired to be kept under wraps. That allegedly show Justin's PR team coordinating a takedown strategy. If those texts are made public, Lively's team is, if those texts are made public, Justin's going to have stuff to answer for, I'm sure. There's thousands of text messages. Look, there was allegations in the complaints that seem to allude that there are thousands of text messages and there's like between hundreds of people. And there were specific instances where they're saying things like, couldn't believe we got away with this. And, we could bury anybody. They're making comments like that amongst each other. The context of that is important. We learned a little bit of the context behind some of that stuff in the 168-page outline. But if the judge doesn't grant this order and he just leaves it open, it's not just Lively that's going to suffer. If there's stuff out there, I'm not so sure what they're going to find against Baldoni, but if they find text messages that shed context as to what's already out there regarding the allegations of a smear campaign, it could be damaging to them. And so, it kind of cuts both ways. I'm still not sure if we're going to get to the point of a settlement. I can tell you this. It's a lot more likely to settle this case if the judge doesn't grant these protections. If Blake Lively believes that the release of additional evidence in a manner that is not protected additionally by the judge is going to harm her reputation anymore, then I think that she could be talked into settling this case. I would say the same thing to Justin. I would think if Justin thinks, because right now he's coming out he's coming out ahead on all of this. If he believes, or his legal team believes, that there's any evidence that's going to get out there that is going to be damaging to his case, that's going to further harm his reputation in Hollywood or affect his ability to gain future employment, then I think that you could convince him to settle, which is to say that I could see a world where these parties settle. When? I don't know. But I think that for Lively, I think the beginning remnants of a settlement are going to largely depend on how the judge ultimately rules on this motion. If they don't grant Lively's additional protections, then I think that you're going to start hearing whispers that Lively's team has reached out to settle. Now, settlement discussions are always confidential. You're not allowed to talk about them. You're not allowed to acknowledge they exist. So I'm not so sure how much you're going to hear about it, but you might hear rumblings. Why? Because of leaks. They happen. Wayward paralegal here or there. I don't know. Somebody's got a relationship with a media outlet on TMZ or something. You never know. But more than likely, if this does settle, what's going to happen is it's just going to be over. And you're going, what the fuck? They just settled it. They just settled the lawsuit for terms undisclosed, NDA agreements, non-disclosure agreements all around. So that was it. So what about the hearing? Let's talk about the hearing on March 6th. I'm going to get into a little bit about what was argued. Oh, I'm trying to keep an eye on you guys when I go on my rants. I apologize. It's really difficult to talk and pay attention to the comments and read at the same time. I get lost sometimes in my rants, and I don't have anybody else to redirect me to the comments. But sometimes if you leave super chats, it rings in my ear, and I could always come on back. Inoldi, Isoldi, Inali Usti. I'm butchering your name so bad. It says, no, you can't settle when someone called you a predator. You'd be surprised what people would be willing to give up regarding their moral scruples if they think that it's in their best financial interest. In other words, what would it take for Justin to settle? Right now, I would say it would be an apology and a full-on affirmation that he is not a sexual predator. But if there was a world, and I'm not saying that there is, so don't jump down my throat, but if there was a world that his attorneys were aware of, oh shit, hold on one second. If there was a world where Friedman and his team of attorneys sat down with Justin Baldoni and said, hey, buddy, I think that you need to take a look at this. And it comes out that there's some embarrassing non-exculpatory evidence out there that might come out, but for a settlement, then you might start saying, you know what, we're just going to both walk away. Enoli says, no, it's Enoli Ucidi. That makes way more sense. Enoli Ucidi. You said it right the second time. My apologies. I hope to never make that mistake again, but no apologies. I will try my best. A mystery singer says, video proof that Snake Lively bit Baldoni's lip. Yeah. And then accuses the other side, that of which you are guilty, Nazi propaganda minister Joseph Goebbels. I don't think this is a case about sexual harassment at all. This is honestly a battle about how media is conducted, how PR campaigns are conducted in Hollywood for the foreseeable future. I'm talking about this is going to be a landmark case that sets the tone for the next 40 to 50 years for some of these media outlets. That's going to be the real legacy of this case. Nobody's going to give a shit about Blake Lively's sexual harassment claims if that's legitimately all there was. The lip biting thing, the walking into her trailer thing, the inappropriate comments thing. Fuck off with all of that. There's just not enough evidence to support it. It's not going anywhere. The causes of actions that are going to be litigated to its merits really is going to be the breach of contract stuff, the defamation stuff. I have heard that Friedman's team does not, where you might normally file a motion for summary judgment for some of these harassment claims. I think that they want to grill her ass on the stand, not just in subpoena. They want to call her ass to cross-examination at trial and make her face up and own up to her lies. So no wonder, do you want me to read the transcript? Because I 100% can if you really want me to. I was just going to break it down. But if you want me to read the transcript, I have that geared up, and I can do that. Matter of fact, fuck it, I'll do it. I'm in, Snow. I'm going to do it. Let me share my window with you. Here it is. Renata says, I don't think either of them will sound good on the stand. I don't know. You really never know how somebody's going to sound on the stand. I know that they have a lot more gotcha moments for Lively that I could readily identify. Maybe they got some stuff with Justin. I'm not sure what their big gotcha moment is going to be for Justin. At least on the harassment stuff. Maybe they could get him on some other things for other causes of action. But the harassment, nah. What's up, Bruce? How you doing, sir? Omar, we want to see your throwback pics. Well, Lauren Knighty has all my throwback pics. And she is currently so baked. She literally texted me to say that she's a vegetable. She said, matter of fact, this is what she said. These are my text messages between myself and Lauren. I hope she doesn't get mad. She texted me, holy shit, I'm a vegetable. Ha, 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 ha. And then I said, LOL, are you safe? And she says, yes, I'm in bed. Ha, ha, ha. I just wander around getting high. I only use it at home. And then I told her to just stay in bed. And I told her, just remember, there is no good reason to go outside naked. And then she said, yeah, I wouldn't do that because I'm not on bath salts. And then, well, that's how the conversation has been going with Lauren tonight. So odds of her coming in tonight is slim to none. Also, the odds of getting a throwback pic are probably not very good either. All right, because of snow, we are going to be doing a play-by-play or a reading of this transcript, and I will give my thoughts. There we go. I'm going to skip over some of the preamble stuff. The court says, good morning. This is Judge Liman. Matt, we're ready to go. Deputy Clerk, Gaversky, good morning, Your Honor. Ms. Gaversky, this is Merrill Gaversky with Willie Carr and Gallagher on behalf of Ms. Lively and Mr. Reynolds. I'm joined by my colleague, Michael Gottlieb, also from Wilkie, Farr, and Gallagher on behalf of the same parties. Good morning, Your Honor. Singrid McCauley, along with my colleague Andrew, they're going through all of the niceties, introducing yourself. Everybody's making their appearances. I'm going to skip over that. Mr. Innes, good morning, Your Honor. In the related case of Jones v. Abel, this is Nicholas Enns of, again, more making appearances. Everybody's going to make their appearances. Mr. Friedman is there. He says, I apologize. I'm joined by my colleague, Summer Benson is here. Teresa Troopson is also here. And I believe Jason Sunshine is here as well from your office, Brian. Yes, and my local counsel, Nick Schuster, is here. Good morning, Your Honor. I'm here with my partner, Kevin Fritz, from Meister, Sealing, and Fane. Good morning. Any other counsel needing to make an appearance? Okay. I have the proposed protective order provided by the lively parties, which differs from my model protective order, principally by adding an attorney's eyes only category. It's opposed by the Wayfair parties. I'll hear first from the lively parties why there's a need to enter this protective order with the attorney eyes only category at this time. And in particular, counsel might focus herself or himself on what kinds of documents would fall within the attorney's eyes only category. That's important because he's signaling, if I were to grant such a thing, it's going to be for specific documents and you need to compel me why they need protections. So this case has been marked by allegations by both sides that the attorneys for each side have disclosed information to the press and have used the case to make claims in the press. We just embiggen this. That's not the subject of today's hearing, but it does prompt the question as to why I need an attorney eyes only category and what information is to be given to the attorneys, but kept confidential to the parties. Ms. Gavernsky, I'm not sure whether you're going to address that or Mr. Gottlieb, but I'll hear from the lively parties first. Thank you, Your Honor, Mr. Gavernsky. Ms. Lively and Mr. Reynolds are the moving parties here, along with Ms. Sloan and Vision PR. We understand Ms. Jones in the related case also has moved for an identical protective or PR. If the court permits, it may make sense for counsel for Ms. Sloan and Vision PR to argue their position in the first instance, and then we can fill in additive arguments after. That's acceptable. Thank you, Judge. Singer McCauley on behalf of Leslie Sloan and Vision PR. You're right, Judge. This is unique. This is a unique case. This is a unique case, certainly. And here we have an instance where there are a number of competitive business parties involved in the case, such that it would require the attorney's eyes only designation for that competitively sensitive information. Your Honor, you entered these similar orders, for example, in your Allstate versus Mata case, which is 2022 WL 500-419. This is common in these types of cases because it's absolutely necessary. When you have competitors who could be receiving information, having that heightened level of an attorney's eyes only designation to protect that sensitive information is critical. Here, the protective order is designed to have a mechanism for the parties to be able to meet and confer to the extent that, hey, the court of random opinions thing is right there. Good on you, Lauren. I did mention that I got this direct from Lauren. She's supposed to be live with me right now, but she's a vegetable. So, and here she is interrupting my stream, even in her absence. To the extent that that is not acceptable to one of the parties, there's a built-in safety net where they can confer over that. And to the extent there's any concern, it can ultimately be raised by the court if necessary. But at the outset, it's going to help facilitate discovery because we can exchange information, but yet protect our client's interests. And this goes on both sides of the fence, frankly. These publicists run on both sides of the V. They are in this space. They have a number of competitively sensitive information they would want to protect. Your Honor, you asked for some information about what that would be. Certainly, these publicists have trade secrets they want to protect. They have their clients' business plans, strategies, marketing plans. Slow down for a minute, Miss McCauley. Sure. Because I am familiar with the Allstate v. Moda, I decided it some time ago, but I do recall it. So you mentioned trade secrets. What else was on your list? Correct. Other clients' business plans and strategies, marketing plans, any discussions in the documents concerning other clients or non-public projects or leads. And I believe I started with trade secrets, the court. In your category of documents discussing other clients and leads, I guess I can understand why, to the extent that this is a feud between PR firms and similar to Allstate v. Moda, if there are leads maybe that would call for an attorney's eyes only category, but simply because they mention clients, this is a case where I suspect there are going to be documents that mention a number of people who are not parties to the case, but who, because of the business they are in, are potential clients. So isn't that category extraordinarily broad? Mr. McCauley, Judge, I can understand that concern. Well, fuck off. I hate when attorneys talk like that. Judge, I have something for you. But here, that is sometimes the trade secret, right? Who their clients are. To the extent these PR companies are warring over the competitive nature of who they can represent, having to disclose that, basically their lists or other information would put them in a competitive disadvantage. And surely, to somebody like Leslie Sloan and Vision PR, who have been unnecessarily dragged into this litigation, to have to then disclose to their competitors information about who their clients are and the sensitive nature of that information, we consider that to be something that would warrant the AEO. And again, Your Honor, this is not absolute. There is a mechanism to the extent something is designated as AEO, and the other side does not believe it should be. There's a mechanism for the parties to confer over that. But this allows discovery to flow out without the alternative that the other side has proposed would require us to hold that back and then come directly to you and have that argument immediately. So this really is a much more reasonable way and very common in these cases. Your Honor, as you well know, I know you're very seasoned in this, but this is a very common way to deal with the issue when you have competitive parties in a case together of this nature. In other words, because the mere identity of the network of people that might be included in discovery might in and of itself be trade secret, it should be privileged. And they're basically stating that if you grant this order, there's not going to be any prejudice, because if they think there's something that they really need to get to or that needs to not be included in this order, then we could have a hearing and meet and confer. In other words, it's going to cause further hearings, and that's not that is not a judicious use of time. That is not very judiciously economical, I guess. Judicial economy. It's late, folks. My brain is probably functioning at 40% right now. Also, they still do the time change thing in California for whatever reason. That means it's like, I'm just operating on 1 hour less of sleep. How about that? So she's arguing that even though it's overbroad, if there's specifics that they have in mind, then they can come and ask. And I got to have a feeling that the judge was like, okay, here's what he has to say. All right, let me hear from anybody else advocating for the attorney's eyes only category. Thank you, Ms. McCauley. Mr. Inns. Yes, Your Honor. This is Nicholas Inns for Jones Works and Stephanie Jones. And just to add to what Ms. McCauley was saying, we certainly join in everything she said. And to our mind, Your Honor, this is precisely what the court just referenced, which is, this is functionally, for our case at least, a feud between public relations firms. As this court, I'm sure, is aware, our complaint includes a number of allegations that theft of trade secrets and theft of confidential information has already occurred by the defendants, in that case, by Ms. Abel and Ms. Nathan, each of whom operate a competing public relations firm, or at least something related to the public relations industry. That begs the question, if it's already been disclosed, then what's the effing harm? He kind of walked right into that one, didn't he? So allowing the attorney's eyes only designation to protect the disclosure of further confidential information is precisely what Your Honor, of course, did in Allstate, and I would also note, in a nearly on-point case, what Judge Engelmayer did last year in the Jane Street versus Millennium Management case, in which he specifically noted the risks of requiring a company that has been aggrieved by former employees to continue turning over confidential information to those former employees. So without repeating everything Ms. McCauley stated, I think those grounds, specifically with respect to this competitively sensitive information, warrants the entry of an attorney's eyes only designation. AEO. The court. So, Mr. Inns, as I hear you, what you're referring to are documents that could be considered to be trade secrets. Correct, Your Honor. And I would generally agree with Ms. McCauley on the categories those would fall into. So business plans formulated for clients, with the caveat that the business plan specifically at issue here, with respect to the clients at issue here between Ms. Jones and Ms. Abel, specifically Wayfarer, we would not expect that to be covered. But other clients' business plans, as Ms. McCauley said, the existence of other clients, any potential future plans that Jones Works has, requiring the disclosure of that to competing firms in the guise of Ms. Abel and Ms. Nathan, would expose Jones Works to a significant competitive injury. All right? Anybody else advocating for the attorney's eyes only category? Yes, Your Honor. On behalf of Ms. Lively and Mr. Reynolds, this is Ms. Konvernsky. Your Honor, of course, all the parties agree that the court should enter at minimum its model protective order. And so the creation of the AEO category that we're requesting is actually built off of that model protective order. The model protective order already protects information of a personal or intimate nature regarding any individual. And so what our proposed AEO category seeks to do is to add an extra level of protection for materials that would fall in that category, but that are especially personal, sensitive, or proprietary, that would cause irreparable harm if it were misused or revealed publicly. I understand that the court, it seems like, is primarily interested in two aspects. One is the reason why confidential designation is insufficient to capture all discovery information, why an AEO designation generally is needed, but also specific examples of the materials that would qualify as AEO. So I'll start with the second and then go to the first, unless the court prefers a different ordering. I'll leave it to you. Great. So as far as some specific examples of the types of materials that we would imagine that would be subject to discovery and that would pose the kind of irreparable harm if disclosed, one example is specific security measures that Ms. Lively and Mr. Reynolds have taken in order to protect themselves and their families from this retaliatory campaign. Defendants have notice and intent to subpoena a third-party firm who Ms. Lively and Mr. Reynolds hired to provide security and privacy protections. That third-party subpoena asks for all documents and communications concerning or to or from Ms. Lively and Mr. Reynolds. So they're referring specifically to a request for discovery that would divulge that information. That what they're referring to is already protected in the court's boilerplate protective order, meaning if it gets out and it's disclosed and it is leaked somewhere, if there is confidential information that gets out and it was leaked by the legal team or Baldoni and we know that they did it, there are severe repercussions for that. They could just basically go to jail. So that's already in place. What the AEO seeks to do is take the further step of not letting any of the parties see it but for their attorneys, so that there's no risk of it leaking out. So it's a measure it's what we have right now are punitive measures designed to deter against leaks. What they want is prophylactic measures to guard against even the appearance or possibility of a leak. That's the difference, really. We will, of course, lodge objections to that subpoena, but in the event that production is necessary, we don't see any reason why the parties themselves need to know the specific details about Ms. Lively and Mr. Reynolds' security measures that they put in place. The court. So let me interrupt you for a moment on that. Are you saying that you believe that Mr. Friedman's clients present a risk to your client's security different than what Mr. Friedman and his colleagues present? I'm not saying that Mr. Friedman presents a risk to your client's security, but your argument raises that issue. Ms. Konvernsky, of course, Your Honor. So you know Mr. Friedman, of course, is an officer of the court and is subject to the professional rules of responsibility as well as additional obligations unique and specific to attorneys. Unlike in typical cases, the parties in this case on both sides of the V, and I like that. I think I'm going to steal that. Both sides of the V. I really like that. Matter of fact, I might use that one tomorrow. Include people and businesses whose entire living is made off of providing information to the press and content creators. I'm not intending to be pejorative. It's just the reality of what they do. They make money and stay in relationships by trading information with them and having techniques for doing so off the record and on background. And in fact, a particular note in this case, the defendant themselves have bragged in text messages about being able to do this in an untraceable way. They're referring to one of those allegations, right? Of being able to publish information without fingerprints and also having individuals who will do anything for them who hate Miss Lively. So we'll pursue further evidence of this through the course of discovery, but the evidence in this case so far demonstrates that there is a significant risk, unlike others that perhaps have been before this court. I also think it's worth noting that the defendants appear to be operating on an unlimited budget that really renders the traditional mechanism of using sanctions to control parties meaningless in this case. Defendant Sarowitz has committed to spending $100 million to ruin the lives of Miss Lively and her family. Objection. That's bullshit. Your Honor, what the fuck? I imagine that might have been I don't know. I've seen those objections before. That would have been a good time for it. And the amended complaint includes a separate quote saying in which Mr. Sarowitz says that Miss Lively and Mr. Reynolds will be the equivalent of dead bodies when he is done with them. We respectfully submit that threats like this raise the question of whether traditional sanctions could possibly deter the abuse of highly sensitive, personal, and intimate information that many parties and third parties may produce in this case. And really, no amount of sanctions could unring the harm that we think would come from this quite narrow category of what we think falls into this AEO designation, the court. When I say the court, I'm referring to Judge Liman. Why don't you get back to, now that you've answered my question, what you mean by the quite narrow category? Because it appears that the Wayfarer parties already are privy to a fair amount of personal information about your clients. So what is incremental that you think poses a particular risk in this case? In other words, I feel like they probably already have a good idea of what you're trying to protect. So what are we actually doing here? Like, your argument was based on stuff that they likely already know. It's really what he's getting at. Ms. Gavernsky. Okay, so I'm going to get to the categories in one quick second, but I just want to make one final point, which is directly relevant to that question. There is an insatiable appetite for any information about this case, no matter how salacious it is. We've seen even the most benign and routine information become tabloid fodder. And just this week, for instance, Your Honor, the Daily Mail published a story on an insider source with information from Mr. Baldoni's legal team about the first group of potential witnesses who Baldoni's team want to hear from, who have been contacted but not yet scheduled. So even the prospect of discovery. And so it's not a stretch for the court to imagine the harm that could come from actual discovery information being placed in the wrong hands. And so what kinds of information? We've talked about security measures. Another category of information that they do not have access to right now is medical information, including relating to the physical and mental health of parties and non-parties alike. So there's, of course, an inherent privacy interest in protecting information about one's health. And we think guaranteeing privacy with respect to medical information is particularly critical here, which is such a stupid argument. If you release somebody's medical information in a case when you're not allowed to do that, and it seems like this boilerplate protective order already guards against it, then you're already going to be in a lot of trouble. I don't get why this argument is necessary. And we think guaranteeing privacy is really what they're after. With respect to medical information is particularly critical here, where it may involve third parties who this court has a responsibility to protect, including pursuant to Seattle Times Co. v. Reinhardt. And then related to third parties, who really are one of our primary concerns here without an AEO protection, is a third category of documents are personal and intimate conversations with really unrelated third parties who have a marginal relevance to this case, where the PR value would be high. but the evidentiary value would be virtually non-existent. We know that there will be significant third-party discovery. We received RFPs from the parties. They are designated as confidential by the defendants, so I'm limited in what I can talk about in open court, which is exactly the point, isn't it? But I can tell you that there are dozens and dozens of third parties named by name, and so we know that there will be production from parties involving third parties. We know that there will be subpoenas to third parties involving third parties, and we think that there is a significant chance of irreparable harm if marginally relevant communications with high-profile third-party individuals who are unrelated to the case were to fall into the wrong hands. And so we think, how stupid would it be that you're being sued for leaking stuff maliciously to the media, and then you would take confidential discovery and leak it during your lawsuit where you're being accused of that very thing? It's kind of ridiculous. So we think that this narrow category would allow the designation for the types of communication that have tremendously high PR value, low evidentiary value, and could do irreparable harm that we would suggest this court does have an obligation to protect. As the Supreme Court in Seattle Times said, if information about third parties is released, it could be damaging to their reputation and privacy. And the government clearly has a substantial interest in preventing this sort of abuse of its process. The court, Judge Liman, Ms. Gomersky, give me an example of the type of personal or intimate conversations that you have in mind, picking out something that would be remote from the actual facts of the case. And on that note, folks, I'm going to pause for about 30 seconds. Here we go. Give me 30 seconds, folks. I'll be right back. And I'm back, folks. Okay. Well, I would have had two other actors, but Lauren turned into a vegetable overnight. And so she was supposed to do this with me. And instead, it was late. Shit happens. Bruce has, what are you saying there, Bruce? When you ask for evidence, like, hey, if you have that sonogram valet, maybe bring it to court. Totally. If anybody in the audience wants to play the other actors or the other lawyers in this case, because you're bored of my voice, request for production documents, Bruce, RFP, that's what that means. Then you're more than welcome to join the stream. Just shoot me a text or something, Bruce or anybody. If not, it's just going to be my monotone ass voice the entire time. So let me continue. So the court wants Ms. Gomersky to give him an example of the type of personal or intimate conversations. Ms. Gomersky says, sure. I'm not asking you to reveal what kind of communications you're concerned about protecting at the same time as you're trying to protect it. But so that I can give some definition to this particular category. I understand, Your Honor. So let's take a complete hypothetical that I would not have access to. Let's say Mr. Baldoni has a very good friend who was a very high profile individual, and he was venting about his day. And he mentioned something about our clients in connection with what happened on that film. That would be responsive, arguably. That would potentially be relevant. It's communication by a party about another party, but its value to the case, its necessity to the case, its evidentiary value would be outshadowed by the fact of who he was communicating with. If he was communicating with a high-profile individual, that all of a sudden creates significant PR intrigue for a communication that to a friend who was a completely private, anonymous individual just would not carry the same kind of weight. Who gives a fuck? I don't understand why if they are high profile people to begin with, why that would need to be protected. Beyond what protections already exist. That is entirely different, Your Honor, from Mr. Baldoni talking with Mr. Sarowitz. That is a directly relevant case, or even Mr. Baldoni speaking with another cast member. That is a different type of relevance by nature of who the individuals are as compared to the category of the types of communications we would suggest would fall into this third protective category. The court. Are there other categories that you have in mind, Ms. Gavrnsky? Well, so you know, one of the reasons that we used the language we did, which was reminiscent and taken from the other protective orders that courts in this district have used, including I just referenced Riverlight 20 CV 07088, We the Protesters 22 CV 9565, and Cowan, involving the Kardashians. That's 12 CV 1541. One of the reasons that we use the type of language that we did without expressly identifying specific categories, like we're using as exemplars today, is because it's hard to predict exactly what might fall into this. But it's not difficult to envision that there would be the type of materials that are speaking about children or speaking about profound mental health issues or locations of private residences or homes. You can imagine there's just a level of personal and intimate information that is particularly relevant because of who these people are, that in an ordinary case may not be subject to an AEO, but would be in here. This case is quite reminiscent of the cases before other courts in this district in Paisley, which involved Prince and Stern, which involved Rita Crosby. And there, the court was particularly concerned about discovery being used as a vehicle for generating content. And the court in Paisley opined that court must be vigilant to ensure that their processes are not used improperly for purposes unrelated to that role. The judge. So a couple of follow-up questions to you. First question is, why wouldn't your objectives, if they are legitimate, be accomplished by something that is more narrowly tailored, that says, in essence, that the names and PII, personally identifiable information of persons who are not parties to this litigation, may fall within the definition of attorney's eyes only, but certainly people who are parties. I mean, if Miss Lively or Mr. Reynolds said something about what was going on the set or said something that is relevant to this case, I wouldn't imagine that that would be attorney's eyes only. Mr. Friedman should have the right to discuss that evidence with his client, Ms. Gavrnsky. I appreciate the court's question and thought that you put into this question. What a fucking douchebag. Kiss the judge's ass a little bit harder, why don't you? I think that it would be too narrow to only limit it to parties because, of course, these parties make their business off of celebrities and people, high-profile individuals. It's highly likely that the content of the communications would indicate clues as to who these people were. That would defeat the point of just abbreviating names. For example, if there's a communication talking about, I was at this event on this date, that would divulge a pretty narrow universe of who might be covered by that. or a communication. It was so great to see you last night. And we know that Mr. Baldoni, Miss Lively, Mr. Reynolds often are photographed out publicly. It would not take much to add one and one together and figure out who the party is. So we think that would be too narrow, and we think that the current draft is certainly in keeping with the language of the court's original protective order and just heightens it for a different level of sensitivity and intimacy. The judge. Now, Ms. Komersky, as you know from my model protective order, and if it's not sufficient, then I can hear the parties with respect to it, but the obligations of the protective order don't just apply to the lawyers. They also apply to the parties. And there's a separate document that people have to sign who get access to confidential information under the protective order that binds them to the protective order. That means that they can be held liable for contempt if they violate it. So why wouldn't that be sufficient? First of all, I presume that people are going to follow my orders. Second, my orders are clear and they violate it, then they're going to be held liable for contempt. And I'm perfectly comfortable having a contempt hearing, and if necessary, authorizing discovery in connection with that. Ms. Governsky. Well, as you and I both know, Your Honor, contempt proceedings and the processes that lead up to them can take quite a while. And in this case, it would not be sufficient to unring the bell if this material is released publicly. Also, Your Honor, I don't believe that sanctions or contempt proceedings are sufficient to protect the very significant concerns that we have here, especially with respect to trade secrets, but also with respect to health and mental health records that really have absolutely no business being publicly released. And I would just suggest, Your Honor, that this is an entirely different case. There are 100 million reasons for these parties to leak information because the PR value is greater than complying with the court's orders. I don't think sanctions will be appropriate. The judge. Well, but there's a huge amount of information, I presume, that is of PR value that's also centrally relevant to the case that will, if the case goes forward, become public. It will be filed in connection with motions for summary judgment as to which there is a presumptive right of access. If the case goes to trial, there are very strict rules against closing the courtroom. And those will be challenging obstacles for the parties. So a lot of what you're talking about is just inherent in the nature of the case. You sue a high-profile person in this industry as to which there's a lot of attention paid, it's going to get picked up by the press. Mr. Friedman sues somebody who's high-profile, it's going to be picked up by the press. There's a public interest in how the courts are being used that the court has to respect. Now, that doesn't mean that you can't share discovery confidentially in order to facilitate the processes of discovery. That's the point of the Seattle Times case. But it does mean that coming down the road, the stuff that's highly relevant is going to end up being disclosed. Maybe not every bit of health information. Do you want to respond to that, Ms. Kovernsky? Of course, Your Honor. And it is absolutely not in our ultimate interest to prevent the public from seeing all the evidence. That is, of course, what is going to happen here. But in order to facilitate the production of highly sensitive materials, especially from third parties, we think it makes sense for there to be an AEO category and then deal with de-designation, whether with respect to summary judgment or with trial, in a holistic way, which is standard in cases, right? I mean, we're going to have to deal with this for confidential, so why not also deal with it for AEO? It doesn't really materially change the process you're describing that would have to happen with confidential. All that we think the AEO would do is actually allow us to keep with Your Honor's schedule, because 6 months to produce all this information, actually 4 months for substantial discovery. If we have to layer into that conferrals anytime that a par or a third party wants to designate it as AEO, I think we're just asking to divert resources to meet and confers and to divert judicial resources towards dealing with this as an ad hoc basis, as opposed to in the manner you have described as we get closer to summary designation. The judge. Isn't it going to lead to meet and confers and coming to the court no matter what? If you designate stuff that's AEO and Mr. Friedman wants to discuss it with his clients and he thinks it's overbroad, I'm going to have to deal with that. So I'm not sure how convincing relieving the burden of the court is or of the parties, because the question is just what the default is, Ms. Gavernsky. Well, but I think, first of all, she's losing. She knows she's losing this argument to the judge. She's starting to fumble a little bit. I've been there. I think the default, if we allow AEO, would allow the materials to get produced much more quickly. It seems to me like the process as contemplated in the PO would require conferral or coming to the court in advance of production. So if we allow the AEO designation in the first place, it would facilitate and allow us to keep this tight 4-month schedule for substantial completion and 6 months for the close of discovery. But I also think, Your Honor, that it would reduce the resources, the burden on the court, because it would allow us to do it in a more holistic, strategic manner. By the time we get closer to summary judgment on trial, the parties will know what the documents they need to use or plan to use. Of course, if we do it all this way, where it's every single material that we all know that you produce a ton of material that never sees the light of day or needs to see the light of day, and if the current process sticks, then we'll be negotiating AEO for every single type of discovery material, as opposed to knowing what we really need to come to the court to, because what needs to be de-designated or have a reduced designation, it will be a narrower world, a narrower universe. It will be less ad hoc. It will be more comprehensive and strategic. It actually kind of makes a lot of sense to me. It's basically competing objections. If we know that we're going to request specific AEO orders for every single discovery order anyway, and we're going to have a hearing about it, then they could just tell us the ones that they want, and then we'll just do the hearings on those. It'll be less. That's what she's saying. The court. I've got a couple follow-up questions, but I do want to let you finish your argument before I ask those questions and then turn to the other side. Ms. Gavernsky. Your Honor, I think we've gotten through everything that I had intended to discuss. The court has quite broad authority here to enter a protective order and broad discretion and an obligation to protect personal interests, and especially of third parties. So we would just submit, Your Honor, that the way that we propose, indiscernible, standard, routine, and narrow way to do so. The judge. Let me ask specific questions about the form of the order that has been submitted, and I'll call on any party who's moving for this to address it. Most of my questions have gone to the broad language that defines what could be attorney's eyes only. One question is whether, if I agree to an AEO category, the word likely should be modified by highly likely. The notion of likely to cause a competitive injury to the producing party is essentially a prerequisite to any protective order. It would not seem to me to be sufficient for an AEO category. Is there anybody who wants to address that from the moving party? Ms. McCauley. Judge, this is Singrid McCauley on behalf of Leslie Sloan and Vision PR. We are comfortable with that from the perspective of the business information we're trying to protect here. Highly likely would be something that would be sufficient in that regard. That's really what we're looking for. We're really looking for to just protect that very, very sensitive information that will cause a business harm to our clients. Okay. Second, in paragraph 1, there's reference to testimony and presentations by the parties or counsel. 2 are in court. There's no way that I'm going to sign a protective order that defines information that is submitted to the court. With respect to information that goes to the court, you're going to follow my individual practices and the law of Second Circuit with respect to confidentiality. I don't need particular argument on that. That is my ruling. Hell yeah. There's no way I'm going to sign a protective order that defines information that is submitted to the court. The last 2 points are that there is a reference throughout to high-profile individuals. For example, the protective order refers to the personal interests of the producing person and or third party, including high-profile individuals. It's not apparent to me whether those words, high-profile individuals, are intended to be language of limitation or why there needs to be a reference to high-profile individuals in this work that is doing. There also is ambiguity in the model protective order that you've submitted, the form protective order that you've submitted, about whether information that is already public is to be treated as confidential or AEO. For example, there may be photographs of family members that have been shared with the Wayfarer parties already, or that are in the press already, that would not, in my mind, be the proper subject of a confidentiality order. Does anybody want to address either of those points? Then I'll move to the Wayfarer parties. And folks, after I've finished with these arguments, I'm going to pause for about 2 minutes, and then we're going to do the other side. Okay, Ms. Gomersky, Your Honor, I'm happy to. We would be fine striking the reference to high-profile individuals and agree that's inclusive in third party. As far as the second point, we do agree that and think it's inherent in the definition of confidential discovery material that it would not cover information that is already in the public sphere or that a party already has in their possession separate from the litigation. Judge, your picture didn't show up on my teams. Who was that who was speaking? Oh, this is Meryl Gavernsky. Okay. And just so it's clear, I should have said this earlier, but because this is a public proceeding as to which the members of the public may be listening in, but not see the visuals, I'm going to ask each counsel before they speak to identify themselves for the record. I should have done that earlier. It was counsel Ms. Gavernsky for the lively parties who spoke immediately before the last attorney who spoke. All right, let me hear from the Wayfarer parties. And then I'm going to pause, give me 60 seconds, and then I'm going to go into Mr. Friedman's arguments, and we will proceed with that. All right. Oh. By the way, folks, those last 2 points, it was kind of reading, getting through it. They weren't really much, there wasn't really much going on in that argument. He was talking about definitions and ambiguities in certain things, the way that they were phrased. Nobody's putting a big fight over those things. That's why they just kind of agreed to it. And now the man, the myth, the legend, Mr. Friedman gets to respond. Let's see how he argues this. Mr. Friedman, thank you, Your Honor. This is Brian Friedman on behalf of, I'll just reference it as the Wayfarer parties, which would include the TAG, PR, Listen Nathan, and whatnot. First of all, I do want to address, I think it's rather offensive that anyone would suggest that we would disregard a protective order. In fact, we're in favor of the court's model protective order. We think it's sufficient to protect parties. And it's not only sufficient to protect the parties, but it feels like what the other sides are asking for is that because there is celebrity, because there are people who are powerful people in the industry, that somehow they get treated differently and somehow there's a different law that applies to them that otherwise would apply to normal, everyday people. The judge. So, Mr. Friedman, I'm going to hear you with respect to that point. I do, excuse me, I do want to make sure that on your list is to address is the PR firms and the feud between the PR firms and the allegations of competitive injury. Yeah, in other words, the judge is not so interested in that argument. He's kind of already on their side with that. But he is really interested in the potential for privileged information leaking out with respect to the PR firms. That's where his legal conundrums lie. And I should lay out one of the premises of that question. The premise of that question is that a reason for attorneys' eyes only designations is that there is information that may be useful to a party in business that when they are exposed to it, they cannot put it out of their minds, and that therefore presents a separate type of risk than the ordinary risk of disclosure or violation of the protective order. So make sure you're covering that point. I do hear you, and I'll permit you to continue to be heard with respect to the general point about this being a high publicity case. Mr. Friedman, sure. And let me address the PR firms, because it's very important within the entertainment industry to understand what's publicized and what's publicized by those very PR firms. Who people represent and who they speak on behalf of is well known. It's in Deadline. It's in the Hollywood Reporter. It's in Billboard. It's in all of the trade publications. People are referenced all the time as which firm that represents them as their publicist. And that's very common. It's not secret as to which firm represents which celebrities all. It's not something that's kept secret. It's not something that's not disclosed to the public. In fact, it's not only disclosed to the public, but on a routine basis, PR agents call up the press all the time to talk about their clients and why their clients either shouldn't be in a story, should be in a story, what their clients are up to, what their clients are doing. It is in no way a trade secret or kept confidential by any PR firm who they represent in any way. And even in this case, we're not really interested in who is represented by what PR firm and what other clients are at issue. That's not the issue in this case. There's not a trade secret or something that's kept confidential by the PR firms that we're interested in at all. In fact, a lot of these people within the PR firms, Jen Abel used to work for Stephanie Jones. And so there is commonality amongst all of that. But most importantly, it's not something that's kept secret. As a matter of fact, it's something that's advertised who they represent. In articles, it's quoted all the time that publicist for so-and-so says this. And in fact, in this case, you'll see numerous text messages from reporters, whether it be at the Daily Mail, whether it be reporters at TMZ, whether reporters otherwise who specifically state the names of the publicists that they spoke with on behalf of those particular clients. This is not confidential trade secret information. And I think that when we talk about publicists and we talk about the parties in this case, I'm reminded of a couple of things. Number one, the case started with the New York Times having 5 weeks worth of confidential information and put out an article with all of that confidential information right out there. That confidential information was obtained by the New York Times themselves from these parties in the case, Judge. That's at least the allegation, Mr. Freeman. That's the allegation. I'm not sure how else it could be, but Ms. Bolger, Your Honor, just to be clear, the New York Times would dispute that allegation. This is where you objection, Your Honor, bullshit. Obviously, the New York Times disputes what Mr. Friedman is saying, the whole thing. Ms. Bolger is pissed. She's uncomfortable with how Friedman is addressing the court right now. The New York Times would dispute that allegation, and it is just an allegation, the court. Thank you, Ms. Bolger, but I will call on you later if you wish to be heard. I'll give anybody else who wants to an opportunity to be heard. I'm taking from both sides what their allegations are, so I understand there are allegations that are made by the lively parties with respect to the Wayfair parties. I understand, Mr. Friedman, you're making allegations with respect to the lively parties and with respect to the New York Times. Parties are free to make allegations to a limited extent, to some extent. That's what discovery and trials are for. Go ahead, Mr. Friedman. Thank you, Your Honor. I actually am not even making an allegation. I'm almost quoting the New York Times, who came out and said, we've reviewed thousands of pages of documents. The judge, you're not testifying. If you want to testify as a witness, I'll put you under oath. So everything you're saying with respect to the facts, I'm going to take it as an allegation. You understand that, Mr. Friedman? I do, Your Honor. And to continue, that's the kind of gazement shit that I get into, man. Ms. Bolger chimes in with the objection. I just want to make it clear that these are allegations. And then you get the whole thing from the judge. Look, I understand they're allegations. And then Mr. Friedman, bullshit, it's not an allegation. I quoted her word for word. Mr. Friedman, I will put you under oath if you want to testify. That was I like that. I believe I would have liked to hear that live. That was good stuff. And to continue, It almost reminds me of the argument being like the old Sesame Street. One of these things is not like the other. And this is not Texaco, Pennzoil. This is not Apple, Microsoft. These are not direct competitors that have trade secret information that is so highly protective. This is not Coke and Pepsi and the formula for Coke and Pepsi or anything like it. These are hardly competitors and information. That's not truly protected at all. As a matter of fact, they use it to advertise. We believe you have broad discretion, Your Honor, and we do believe that the parties seeking the burden, the protective order has the burden of showing good cause that it exists for issues that and an issue of what would be a strenuous attorney's eyes only provision. We think it's important and frankly necessary that we are able to utilize our clients who are in this industry and to discuss with our clients those documents and other information that could be helpful for us defending the case and clearing our clients' names in the case. And we think that's imperative. And it would be a burden on us every single time to come into court and argue about whether an AEO provision, which is highly unusual, is proper. In fact, Your Honor, your model order addresses all of this. It says that if you need greater protection, you're welcome to come into court and ask for greater protection. First to meet and confer with the other side. Of course, things like medical records of Miss Lively, she's alleged emotional distress. There will be an IME. We want to dispute in a meet and confer that the information would be confidential and could even be attorney's eyes only information. That's an issue in the case because of the damages in the case. And we certainly are not interested in saying that that's something that somehow is not protected. But this is a confidential protective order. Things are supposed to remain confidential. We intend to follow the confidentiality. And there are provisions in the order which fully protect all of the parties. And if they need some sort of greater protection, and for some reason they don't need our clients to see something, then they can make a showing for it. But there just has not been a specific showing at all today. And my concern is that the burden from the Lively parties is they are trying to shift the burden and somehow that there should be an AEO provision in here, and we should have to prove up and run into court every single time when we feel like that's a burdensome process, that's an unnecessary process. It's all addressed in your model order, Your Honor. And in fact, it's not only addressed in your model order. There is a specific provision that says that any party can come in at any time. If they think they're not being protected by the model order, we're prepared to adhere to the model order. We think the model order protects all of the parties. And frankly, we see no difference because someone is a celebrity or because someone advertises their client as a PR agency that they should have the right to somehow indicate that this is a trade secret when it's clearly not. The judge. So one difference between this case and many other cases is that there are allegations in this case by each side against the other, that the other has leaked confidential, sensitive information that they were entrusted with him through their job position in ways that are difficult to trace. That's not an allegation about the attorneys. It's an allegation about the parties, and it is something that I have to take seriously. So why wouldn't that support at least some limited amounts of an AEO provision? Mr. Friedman. It wouldn't support it, Your Honor, because the confidentiality in the order should be enough. I mean, what you've seen in the model order, it does protect that. My concern is this. So far in the case, what has been disclosed are addresses of my clients and proofs of service, which we have not done at all. There have been addresses now that the world knows about where certain clients live and where they reside, which has been highly offensive and unnecessary, Judge. So let's actually now drill down a little bit more on categories. It may be a burden on the parties to protect certain PII, such as addresses, medical information, email addresses, telephone numbers that are really of marginal value, no value to an attorney, consulting with their client as to how to defend or prosecute the case. There are other specific categories that were mentioned by the other side, such as beyond the physical health information, but that included security measures, trade secrets, business plans. Maybe you can address yourself to the specific things that the other side said, presents particular concerns for them and why those concerns are not appropriate ones for an AEO category. Mr. Friedman. Your Honor, no one is interested in what somebody's security is doing. It hasn't even been the suggestion of anyone that what is a security guard or a security person. It's not even remotely relevant to the case at all what somebody's security is doing. It is a complete ruse and not relevant at all to the proceeding. So I don't know why that even comes up at all and why that's even a concern. With respect to Ms. Lively's medical records and psychological records based on her own damage allegations, there's a process in the model order that says meet and confer. We would fully intend to agree that that should be something that should be designated as highly confidential and something that should not be disclosed. We have no intention in disclosing that. We have no intention in violating the court's order. But the point is something going to be ordered that's so restrictive that's not even, it's so premature for this. It's not even something that's at issue in the case itself yet. It's not even something that's relevant to the case itself yet. And it's guesswork on whether something is going to come up or not. There's a procedure in here to meet and confer. No one is disclosing anything to the public or anything like that. And we can meet and confer. And if there's a disagreement as to something that should be an AEO, we can present it to your honor. But it's highly unusual to have a blanket AEO provision and us not being able to utilize that with our clients and to gain information from our clients if it's relevant to the case itself. And certainly if there's an objection and they want to meet and confer about something and want to try to designate it with some sort of higher standard, we'd be happy to meet with them before sharing that information with our clients. We'd be happy to give them that opportunity, like the model protective order allows, and allow them to go to court and ask for higher protection if we object. The likelihood is most of these things we won't object to, likely, but they are not even at issue yet. The idea that we would care what Mr. Reynolds or what Ms. Lively's security people are up to in terms of how they are being protected or otherwise is clearly nonsense. The only people that have been mentioned, frankly, third parties in this case, is an executive, I won't repeat her name, from Sony, whose name is mentioned 3 times in Ms. Lively's complaint. And we've gone to great lengths to not mention third parties by name and things like that. I think it's completely unnecessary. I think the model order completely protects everyone. And certainly if we're meeting and there's a disagreement, they can go to court, like the model order provides, and ask the court for greater protection. And we can discuss it before it's disclosed to clients. We can give them that right. Judge, how does that work? They produce it to you, and there's a pause before you present it to your client for them to press the claim that it's AEO. Is that what you're saying, Mr. Friedman? No, I think what he's saying is when they produce it, they could flag it and then have a discussion about it before it's ever. I'm trying to predict what Friedman's never said. I'll let Mr. Friedman speak. No, I'm saying when they produce it to us, that they say, hey, we want greater protection on this particular document. Please don't share this with your client, which we would agree to. We would meet and confer. If we met and confer and agreed on that, then there's not an issue. If we met and confer and didn't agree, we'd still be holding on to it, not sharing it with our client until they had an opportunity for your honor to make that decision. There's no harm whatsoever under the model order, and that's the court. Isn't that actually what the attorney's eyes only provision does? The only difference between what you're saying and what the attorney's eyes only provision does is it gives a little bit of definition to attorney's eyes only. And it means that you're not just promising them that you're not going to disclose the information to your clients. You're bound by a court order. I mean, it's easy enough to write into this protective order that if there is not a meet and confer within a certain period of time after production, then the information will not be deemed to be attorney's eyes only. Provisions like that puts a little bit of process around it. That's actually really smart. Mr. Friedman, the difference, I'm sorry to interrupt, Your Honor. Go ahead. The difference is the burden and who is the one running the court. Under the model protective order, they are entitled to go to Your Honor and ask for greater protections. The model protective order is no different for this case than it should be for any other case. And the difference is the burden of who has to run the court to be able to either try to undo something that they deem an attorney's eyes only provision, or whether it's their obligation to go to court and seek greater protection if they can't agree on it. And that's the difference. We shouldn't have to run to court every time that something is given greater protection. That is not something that should be attorney's eyes only. We shouldn't be put in a position where we are the ones who have to run into court every single time and say, no, This shouldn't be blanketly just given attorneys' eyes only protection. It should be their burden because this is what they want to designate to go into court and get greater protection. There shouldn't be a presumption that they're entitled to that greater protection. And there's no harm. There's no damage. There's a process to meet and confer. And there's a process to go in and see, Your Honor, which is what the model protective order provides. The burden shouldn't be on us to do that. It should be on the party seeking attorneys' eyes only protection. Judge. Anything else from you, Mr. Friedman? Yes, Your Honor. Mr. Friedman, you're now on mute, so I don't hear you either. Am I still on mute? No, you're not on mute anymore. Terrific. Sorry about that. I apologize. I do that all the time. I did that just yesterday. I had a remote appearance hearing and I muted myself and started talking. All right, the proposed protective order in paragraph 16. Okay, give me a second to go there. Yes. It basically says you cannot transmit any confidential information over the internet or use in communications that flow through the internet, including but not limited to via text message, Snapchat, Instagram, TikTok, Reddit, YouTube, or any other online or social media platform. That provision is so overbroad, Your Honor, that it would prevent me from sending an email to my own colleague about anything that would be considered to be confidential discovery material because you have to use an internet platform system to use email. It's so hopelessly overbroad and unnecessary. And that's why, first of all, it's not in the model order. Second of all, it's not even usable in the form that it talks about. The judge. I'm going to hear from the other side with respect to that. Ms. Gunvernsky. Do you want to hear it now, Your Honor? No, I'll let Mr. Friedman finish. Is there anything else, Mr. Friedman? I'll just close by saying that, Your Honor, I don't think that because this case is so different than any other case, that what it requires is that persons of celebrity switch the burden. And the burden has to be on the other side to run to court when they object. The model protective order fully protects everything we've heard about today, and it fully has a mechanism in it which we agree with, which allows the other side to go to court if they seek greater protection on certain issues. And I have no doubt that we'll be reasonable in being able to meet and confer and hopefully being able to work something out on a meet and confer. My concern is what's going to happen is things are going to be stamped by one of these many parties as attorneys' eyes only. And we'll be seeing, and we enjoy seeing, Your Honor, but I think you'll see maybe too much of us and possibly get a little bit tired of us under the scenario, the way that it's proposed in the modified order, the court. Is there anybody else who wishes to be heard in opposition to the protective order with the attorney's eyes only provision? Okay, now let me hear from the proponents of it. Ms. McCauley, did you wish to, or Ms. Gavernsky? Ms. McCauley. This is Ingrid McCauley. I'm happy to address it briefly and then turn it over to Ms. Gaversky. Just to have this resonate with the court, Your Honor, Mr. Friedman made the argument for us. This is exactly why we need an AEO. While he used disparaging language about my client's business, certainly her trade secrets and her business information is entitled to protection. She was dragged into this court inappropriately, and she should not have to give over competitive information. So let's just talk about that a little bit, the judge. It'll be for me to determine whether she was brought into this case inappropriately. Go ahead. Understood, Your Honor. But the point that Mr. Friedman made was he was not so interested in this material. If that's the case, then he has no argument against the AEO designation. It allows the parties to have that designation, protect their sensitive commercial business information. And if there is something in that he believes he needs to share with his client, there's a meet and confer process. And then if it can't get resolved, it goes to court. But that's a much smaller universe of what ultimately goes to the court. Rather, with the protective order as it is now, all of that, we'd have to go to the court before any of that could be disclosed. So Mr. Friedman made the points for us, Your Honor. This is exactly why, Judge. So why aren't your concerns entirely satisfied by a draft of this that creates and permits you to designate something as presumptively attorney's eyes only, or a claim of attorney's eyes only, but then requires you to establish to my satisfaction, if there's a dispute over it, that it is the type of information where there is an incremental risk which disclosure to Mr. Friedman's clients would be unacceptable. Ms. McCauley. It's a very fair point, Your Honor. And if that's the only stumbling block with respect to why Mr. Friedman is objectionable to this, because he doesn't want to have to be the one moving in court, I think that's something that the court can handle. Certainly the point is to be able to protect this information. So I've seen protective orders where there's a period of time after which the dispute is that then the party who wants to protect that information has to move to protect that information. The procedure by which this happens is not the concern I have. The concern I have is that information of this nature can be protected at the outset, and it is not disclosed to the competitive clients until such time that the court deems that would be necessary. The court. Well, so maybe, though, you should address Mr. Friedman's point that the client's PR agencies are well known to the people in the industry and are known to competitors. It's not a case like the Allstate case, where there's virtually an unlimited list of clients. The people will be of public interest is the limited group of people who are stars, right? Or budding stars. And Entertainment Weekly knows who they are. The Hollywood Reporter knows who they are. And they also know who the agents are because those are the people who call them up. And that's what even the complaint here establishes, Ms. McCauley. Of course, Your Honor. And that's not our argument. Our argument is within the context of the work that they are doing. There are clients that are not yet disclosed. There's clients that they are actively seeking to engage with. They don't want to turn that information over to their competitor. There is, as we said, marketing plans, business strategy, discussions of non-public leads and other things that they are going after. All of these are trade secrets of our clients. All of this is information they should be entitled to protect and not disclose. Now, we're not saying the lawyers can't see it. We're saying their competitor cannot see this. Judge, so I take it, Ms. McCauley, from your argument, the documents such as the marketing plans with respect to It Ends With Us would not be considered to be attorney's eyes only. That's highly pertinent information to the case. Some, if not all of it, is information that the parties would have been privy to, and it's already dated. The movie is out. Correct, Your Honor. We are talking about a limited scope of information. So you're not talking about the marketing plans for It Ends With Us. Correct. I'm talking about my client's other marketing plans for other customers that she's dealing with that could cross over in the broad scope of what the discovery request in this case would be. And just to take issue with what Mr. Friedman said about arguing about this now, it's absolutely 100% commonplace, as you know, in commercial litigation, to upfront define and set forth a protective order so that the parties can cohesively go forward with discovery. So this is an appropriate conversation to be having now, even though we have not yet received discovery requests. We know that the scope of discovery, that the scope of what some have already been requested in the case itself encompasses this type of information. And because we want to ensure that we're able to protect our client's information and not just take Mr. Friedman's word for it, that he would hold it in good faith for some period of time, we really need this AEO designation. And Judge, this is not far off from cases where this happens all the time. I mean, AEO, while it's not in the model protective order, it is not unusual when you're in a case with business competitors where that information needs to be protected. So we would ask, Your Honor, to entertain this. If for some reason the court feels that it is not being utilized in the appropriate way, the first time we're in front of you, you're able to address that with the parties. So I think this gives us the necessary protection to allow the parties to proceed appropriately with discovery in a logical manner without having to burden the court. And if for some reason it doesn't feel to the court that it is being utilized in an appropriate way, the court can address that with us and we can change that at the time if it's necessary. But I believe that this is the only way to protect that competitive and highly sensitive information at the outside of discovery. And I appreciate the court's time today. Wait, it is a lot of reading. All right. Thank you, Ms. McCauley. Ms. Gavernsky, do you wish to be heard? Yes, Your Honor. I have 8 very discrete points. I'll start with the low-hanging fruit. As far as paragraph 16, I think we can all agree that the intent of this provision is not to prevent the emailing internally. It's to prevent the publication of any confidential discovery information on the internet. So we would be happy to propose modified language, or better yet, we'd be happy for Mr. Friedman to provide modified language to us. He never objected to this or provided any suggestion that there was an issue or alternative language during the conferral. So we'd be happy to consider alternative language. With respect to his accusation about publicizing his client's addresses, my understanding is those addresses were pulled from publicly available sources, and so they were already in the public domain. But separate and perhaps more importantly, Mr. Friedman or no one from his team ever informed us about improper disclosure. Of course, if they had, we would have properly addressed it and consider the points. Point 3, Mr. Friedman made some reference about his attempt to limit the number of third parties. Again, I am restrained by their own use of the confidential designation on their indiscernible. But I will represent that there are dozens and dozens of third parties specifically named and identified, even in, I'll stop there, specifically named. So he knows full well that there will be many third party privacy interests implicated in his own requests. Number 4, I think that there is a false assumption here that is predicating all of Mr. Friedman's arguments. He's assuming that Miss Lively and Mr. Reynolds and Miss Sloan and Vision PR will be the only people availing themselves of the AEO designation. This does not pose a burden uniquely on him. He said many times we would have to go to the court or it's burden shifting to us. They would be available. They would be availing themselves of the AEO provision, just as they already have availed themselves of the confidential provision before a PO is even in place. And not to mention, there are third parties. They are just assuming that every third party who designates AEO will be someone who they are contrary to. It may be, in fact, that we have issues with third parties over a designation or use of AEO provision. So the process that's contemplated here is not placing an unfair burden on him. It's the exact same burden as to every individual, the judge. Mr. Komarsky, you're not making the argument to me that there shouldn't be an AEO category because you want to share the information with your clients, are you? No, go ahead. No, I'm sorry. I'm not making that suggestion. What I'm saying is that he was arguing that this having to come to the court to de-designate places a different burden than the one established in the protective order, as if it would be uniquely placed on him. I don't think that that's a unique burden for him. Party will have that when they disagree with an AEO designation. I also think Mr. Friedman made our point for us, and it's difficult to understand why we're here. One, he's attempting to create a whole new process for, as Your Honor knows, is essentially the AEO process. So rather than have to take their word for it or give them the benefit of the doubt or trust them, it should just be memorialized the way we propose. And related to that, he agrees that the medical records would be AEO, that security would be AEO. So he here has admitted that there shouldn't really be a dispute over the text of categories we've been discussing today. My next point. So, Ms. Gaversky, I take it that you would not. It would satisfy your concerns for there to be a protective order in place that has a category that is a claim of AEO, but that if you don't come to the court within a certain period of time and you don't justify why there is an incremental, unacceptable harm of disclosure to this, to the parties themselves, would lose that claim of AEO. Am I correct? That would satisfy your concerns, Ms. Gaversky? No, I don't think that would satisfy my concerns, Your Honor. First of all, most of the cases respectfully that I've done, set it up this way, where you can write designated as AEO, meet and confer. If they want to de-designate it, they can de-designate it. This is the typical process that is common in my practice. They're both basically arguing the same thing. Why should we have to go to court every time we have to de-designate something? They're saying, why do we have to go to the court every time we have to designate something? There's clearly somebody's going to have to do it. And so they're both basically making the same point. But I think that the judge's point is with this AEO, this overly broad AEO provision, is that they have way more persons that they've already identified who would run under the scope of an AEO. That would require maybe perhaps more hearings than necessary. Anyway, Ms. Konversky continues, I fear that doing it this way, especially on the fly, without actually seeing the language or how it would work, because again, we were never proposed with this option during the conferral process. I fear that this will just create the same challenges and problems we had with what was in the model protective order, which is it would make us have to come over and over to the court in a piecemeal ad hoc way, as opposed to at a point where de-designation makes sense. And what it does do, the judge, what it does do is it protects against the promiscuous use of an AEO category, requires you to really think about it and to think about it after a meet and confer, Ms. Konversky. But I think it places a really unfair, disproportionate burden on third parties. I really do. She really, really does. I think with the type of materials and individuals we're dealing with, they should be entitled. They are third parties here. The rules try to prohibit the additional burdens on third parties. The burden should be on the parties if they want to de-designate third-party materials to go to the court and not make the dozens and dozens of third parties who are going to be implicated here run to the court. I've never seen something like that, and it doesn't feel consistent with the idea of reducing burden to third parties. I want to be mindful of the time, so I'm trying to be very quick. Mr. Friedman said that security is not even remotely relevant. Well, if that's his position, then he should withdraw the third-party subpoena he served on a third-party security firm that asked for all documents and communications concerning Lively and Reynolds. And to Lively and Reynolds, this is a firm hired for their personal security. And so it's difficult for me to understand how we can be claiming that this is a fictitious concern and consistent with the third-party subpoena that they served. Two more very quick points. One is, in their opposition, it really wasn't an opposition. It was criticizing, casting aspersions, which I won't go into. And then it was a single paragraph that amounted to claiming that Miss Lively had no privacy interest because she has chosen to defend herself and speak out against claims of sexual harassment. I respectfully suggest, Your Honor, that we are dubious of his claim, that no doubt we will be reasonable. If their starting position is that a woman who speaks out against sexual harassment is entitled to know and discernible. What the fuck does she keep saying? They can't understand. Judge, I'm going to assume that everybody is going to be reasonable in this case, Ms. Konversky. We would hope so, Your Honor. Finally, it's my assumption for you as well as for Mr. Friedman. Go ahead. Well, I can commit to that, Your Honor. And finally, my last point is Mr. Friedman started his argument with saying that we are asking to be treated differently. And he multiple times, I counted at least twice, he said that AEO provisions are highly unusual. Well, I would suggest, Your Honor, that they are not highly unusual. A significant number of cases include them. And I would note, Your Honor, that Mr. Friedman himself has used an AEO designation in his defense of Mr. Tarantino in a case in California where they included an AEO provision specifically for any information that there is a good cause or a compelling reason why it should not be part of the public record of this case. Or, I'm sorry, that its disclosure to another party or non-party would create significant risk of serious harms that could not be avoided by less restrictive means. So he would proffer that not only is this not unusual in many cases, it appears not to be unusual to Mr. Friedman either. The judge. Read that language to me again. Significant risk. Ms. Konversky. He said, let me pull up the exact language here to read to you. Highly confidential, attorney's eyes only, extremely sensitive confidential information or items, disclosure of which to another party or non-party would create substantial risk of serious harm that could not be avoided by less restrictive means. This was the Miramax versus Tarantino case in the Central District of California, 21 CV 08979. I'm happy to answer more questions. Otherwise, I'll cede. Judge, anybody else wish to be heard on either side? Just identify yourselves and speak. Otherwise, the court will take this under submission. Mr. Friedman. Yes, Your Honor, briefly. Mr. Friedman. Okay. Just to quickly address the Tarantino matter involved actual trade secrets. It involved actual screenplays, pages from Pulp Fiction. And it was a very different situation. And as the court knows, these matters of attorney's eyes only provision are typical, but they are typical in trade secret cases, not cases like these. And I think it's important that the court understand that this is a case where no one has any intention of beating up or repeating or somehow harming Miss Lively in any way as to her allegations. In fact, she filed 138-page amended complaint with nearly 500 paragraphs where she detailed the sexual harassment claims and put that out there. This is a case about, and quite frankly, we've seen a lot of these where my clients have been adjudicated as guilty right when the case was filed. And my clients have a right to defend themselves. They have a right to tell the truth. They have a right to transparency. That is not in any way abusing the victim, Your Honor. All we're trying to do in this particular case is agree to the model protective order, which we think completely protects the parties. And it places the burden on the party who is going to designate something as attorney's eyes only, or it wants greater protection. It forces them to go to court. And it's a way of stopping what's going to inevitably happen in this case, where everything is going to be stamped as attorney's eyes only. And the burden should be on that party that takes that kind of extreme position for whatever reason they do. And frankly, we think the model protective order is pretty good. I mean, it's actually a really well thought out, well protected document. Thank you very much for your time. Thank you, Mr. Friedman. I do think that the model was well thought out. The question of whether it's appropriate for this case is something that I'll take under submission, and I'll give you my views soon. I will end with an observation that I made during the course of this proceeding, just so that there's no misunderstanding. The reason why we're talking about protective orders now is that we are in the discovery phase. And in Seattle Times versus Reinhart, the Supreme Court made it quite clear that courts are encouraged to use protective orders to facilitate the provision of information from one side to another, which in the discovery phase of a case is intended to be a private exercise. It doesn't take place in open court itself. This is a case as to which there has been a lot of public attention, and there should be no confusion that with respect to anything that's filed in court or that takes place in court, there is a presumption of public access. The Second Circuit has been quite vehement about that, has been quite strong about that, and the court is strong about that in terms of protecting the rights of the public to know how the court is being used. So you are all on notice of that. And whatever I decide with respect to the protective order will not affect the way in which documents are used in court proceedings. There will have to be a separate application with respect to that. And that concludes the proceedings. I'll take it under submission. Thank you all for excellent presentations. And that was the reading of the transcript from the March 6th hearing. What do you all think of that? Jesus Christ, that was a lot of reading. I think that the case was argued excellently by both sides. Honestly, I think that they were essentially arguing the same points. If you don't have this blanket AEO protection, then we're just going to have to keep coming back to court to get specific protections for specific third parties. And then Friedman turns around and says, look, if you issue a blanket protection, then we're just going to have to keep coming back to court every single time we need to de-designate somebody. They both made that similar point. Where are we going with this? I really think he's going to, I don't know if he's going to issue an AEO. I think he's going to make Lively's team specifically identify who it is that they want to have an AEO and have like an individual hearing for all of them. I think he might do something like that. I don't know, but it doesn't sound like he is really in favor of extending the model protective order any further. It's undeniable that this is a public case that everybody kind of already knows everything about. All of the third-party information is largely already out there. To the extent that it's not, then, fine, show me. So we'll see. But folks, I've been talking now for almost 2 hours, which is an hour longer than I had anticipated. But I love you all. And thank you to Lauren Knighty for getting me that transcript. It sucks that she couldn't join me on the stream. But, I also think that if she was on the stream, this might have been like a 3-hour show instead of a 2-hour show. So I love you folks. You guys get a good night's rest, and I will see you all tomorrow. Bye-bye.